I have presided over thousands of cases in my years on the bench. I have looked into the eyes of fraudsters, con artists, grieving parents, and broken families. I have heard lies so polished they almost fooled me. I have watched justice arrive late, arrive ugly, and sometimes arrive in ways that left the entire courtroom breathless. But there are cases, rare ones, that follow you home. Cases that sit in the corner of your mind long after the gavel falls. Cases where what you witness is not simply a legal dispute, but a collision between raw human arrogance and the kind of quiet courage most people never get to see up close. This was one of those cases. His name was Dr. Marcus Hale, 47 years old, chief of cardiothoracic surgery at one of the most prestigious private hospitals in the state. The kind of man who had spent 2 decades being told he was exceptional and had, somewhere along the way, begun to believe that exceptionalism was the same thing as immunity. He walked into my courtroom on a Tuesday morning in late October wearing a suit that cost more than most people's monthly rent. His posture was immaculate. His expression was controlled in that particular way that very intelligent, very dangerous people learn to control it. Not blank, not cold, but calibrated. Every muscle in his face arranged to communicate exactly one thing. I do not belong here, and everyone in this room knows it. I noticed it immediately. 30 years on the bench teaches you to read a person in the first 30 seconds. And what I read in Dr. Marcus Hale that morning was not nervousness. It was not guilt. It was something far more unsettling. It was contempt. The plaintiff was a woman named Rachel Morgan, 34 years old, a registered nurse with 11 years of experience in the ICU. She sat at the opposite table in a navy blouse, her hands folded in front of her, her eyes forward. She did not look at him when he entered, but I watched her jaw tighten just slightly, in the way a person's jaw tightens when something they have been dreading finally arrives. Her attorney had filed a wrongful termination lawsuit. The claim was straightforward on paper. Rachel Morgan had been fired from Hargrove Medical Center 8 months prior, following an internal complaint lodged by Dr. Marcus Hale. The complaint alleged insubordination, unprofessional conduct, disruption of surgical procedure. Rachel Morgan's version of events was different, profoundly different, and it was her version that had brought us all into this room. I called the court to order. The gallery was quieter than usual, the kind of quiet that settles over a room when people sense instinctively that what they are about to witness matters. I have learned to trust that quiet. In all my years on the bench, that particular silence has never been wrong. The defense opened confidently. Dr. Hale's attorney, a sharp, well-dressed man named Gerald Fitch, framed his client as a world-class surgeon whose authority in the operating room was not arrogance but necessity. Lives depended on his decisions, split-second decisions. And a nurse who undermined that authority, regardless of her intentions, created danger for every patient on that table. It was a clean argument, professionally constructed. The kind of argument designed to make the jury feel that questioning Dr. Hale was itself somehow reckless. I watched the jury. 7 of them nodded, almost imperceptibly, but I caught it. Gerald Fitch caught it too. He allowed himself the smallest possible smile before returning to his seat. Then Rachel Morgan's attorney stood up. Her name was Diana Cole, younger than Fitch, less polished. But there was something in the way she placed her legal pad on the podium, deliberately, without rushing, that told me she was not intimidated. Not even slightly, she looked at the jury for a long moment before she spoke. "Ladies and gentlemen," she said quietly, "Dr. Hale is correct about one thing. Lives do depend on what happens inside that operating room. In fact, it is precisely because of that truth, that one life, specifically, that we are all sitting here today." The courtroom shifted. I felt it more than heard it. And then Diana Cole said a name that nobody in that gallery had heard before that moment. A name that made Rachel Morgan close her eyes briefly at her table. A name that made Dr. Marcus Hale, for the first time since entering my courtroom, look down at his hands. The name of a patient. I have learned, over the course of my career, that the most dangerous moment in any courtroom is not the verdict. It is not the closing argument or the cross-examination or even the moment a witness breaks down on the stand. The most dangerous moment is the one right after a name is spoken and the room recognizes what that name means. The patient's name was Thomas Ellery, 61 years old, a retired high school science teacher from a small town 2 hours outside the city. He had driven himself to Hargrove Medical Center on a Thursday morning in February, complaining of chest tightness and shortness of breath. By noon, the cardiology team had determined he needed emergency bypass surgery. By 2 o'clock, Dr. Marcus Hale was scrubbing and Thomas Ellery survived the surgery. But he did not leave that hospital the same man who had walked in. Diana Cole laid it out methodically. During the procedure, Rachel Morgan, serving as the primary scrub nurse, had observed something, a discrepancy, a medication dosage that did not align with what had been prescribed. She flagged it. Quietly, professionally, in the precise language that 11 years of ICU experience had trained her to use. Dr. Hale's response, according to 3 witnesses present in that operating room, was immediate and unambiguous. "I don't answer to nurses. Hand me the clamp and stay in your lane." The medication was administered. The surgery continued. Thomas Ellery spent 19 additional days in the hospital recovering from complications that his own cardiologist, not Dr. Hale, would later describe in a written report as consistent with the kind of adverse reaction the flagged dosage was known to produce. Rachel Morgan filed an internal report the same evening. 48 hours later, Dr. Marcus Hale submitted his complaint against her. 72 hours after that, she was called into HR and handed a termination letter. 11 years. Gone in 3 days. I watched the jury absorb this, watched the 7 who had nodded during Gerald Fitch's opening statement go very still. There is a particular stillness that comes over people when they realize they were about to be wrong about something, and more importantly, when they realize they almost did not catch it in time. Diana Cole requested her first witness. Rachel Morgan took the stand. I have watched thousands of witnesses sit in that chair. Some tremble, some perform, some collapse before the first question is finished. Rachel Morgan did none of these things. She sat with the straightness of someone who had rehearsed not composure, but honesty, which is an entirely different thing, and one that is impossible to fake at close range. She described the morning of Thomas Ellery's surgery with the precision of someone who had replayed it 10,000 times. The preparation, the procedure, the moment she noticed the dosage, the exact words she used to flag it, the exact words Dr. Hale used in response. Gerald Fitch's cross-examination was aggressive. He challenged her memory, questioned her credentials, suggested she had misread the chart. A chart, he reminded the jury, that she was not the primary responsible party for. He used the word confusion 6 times in 8 minutes. I counted. Rachel Morgan did not waver once, but it was what happened next that changed everything. Fitch made a mistake. It was a small one, the kind that only becomes visible in retrospect once the damage is already done. In his effort to discredit Rachel Morgan's account of the operating room exchange, he stated confidently that no other staff member had corroborated her version of events. Diana Cole was on her feet before he finished the sentence. She had a document, a sworn affidavit from the anesthesiologist present during Thomas Ellery's surgery, a Dr. Patricia Howe, who had submitted her account not to the hospital's internal review board, which Dr. Hale had considerable influence over, but directly to the state medical board 6 months prior. The affidavit had never been disclosed to the defense because the defense had never asked the right questions to find it. Gerald Fitch stood very still at his podium. I watched him process what had just happened. I watched him look at his client. Dr. Marcus Hale was still composed, still controlled. But something behind his eyes had shifted, something small and cold and very precise. And I recognized it immediately because I had seen it before in men like him. It was the moment a person realizes that the version of reality they have been performing is no longer the only one in the room. I called a 15-minute recess. In 30 years, I have used recesses for many reasons. To allow emotions to settle, to give attorneys time to regroup, to let juries breathe. That afternoon, I used it for one reason only. I needed a moment myself. Because what I had just seen on that stand, what Patricia Howe's affidavit described in precise, clinical, devastating detail, was not simply a workplace dispute. It was not a misunderstanding between a surgeon and a nurse. It was a pattern, a documented, deliberate, institutional pattern of a man who had spent years using his position to silence anyone who dared to suggest he was capable of being wrong. And Thomas Ellery was not the first patient in that file. He was the 4th. There are moments in a courtroom that no amount of experience fully prepares you for. I have watched confessions unravel in real time. I have watched ironclad defenses collapse under the weight of a single photograph. I have watched men who swore on their children's lives be proven liars before the ink on the Bible had dried. I have seen grief so raw it made the bailiff look away, But what happened in my courtroom that afternoon, in the 40 minutes following that recess, was something I will carry with me until the last day I sit on this bench. Diana Cole called Dr. Patricia Howe to the stand. She was 60 years old, 28 years as a board-certified anesthesiologist. She walked to the witness stand with the measured, unhurried gait of someone who had long since stopped needing anyone's approval. She took her oath without ceremony. She sat down. She looked at Diana Cole and waited. The gallery was so quiet I could hear the ventilation system above the ceiling tiles. Diana Cole asked her one question to begin. A single question, simple and direct. Dr. Howe, in your 28 years of practice, have you ever filed a sworn affidavit against a colleague with the State Medical Board? Patricia Howe did not hesitate. Once, she said. In 31 years of working in operating rooms across 4 states, I have done it exactly once. And who was that affidavit filed against? She looked across the courtroom, not at Gerald Fitch, not at the jury, directly at Dr. Marcus Hale, the defendant, she said. What followed was 40 minutes of testimony so precise, so methodical, and so quietly devastating that I watched 2 jurors take notes with the urgent, slightly desperate energy of people trying to make sure they did not forget a single word. Patricia Howe had been present for 3 of the 4 cases referenced in her affidavit. She described each one, not dramatically, not emotionally, in the flat, clinical language of a scientist documenting observed phenomena, which made every word land harder than any dramatic delivery could have. In each case, a member of the surgical team had flagged a concern. In each case, Dr. Hale had overridden it. In each case, the patient had experienced post-operative complications that fell within the predictable range of what would occur if that concern had been valid. In each case, the team member who raised the issue had faced some form of professional consequence within 90 days. One had been reassigned. One had received a formal performance warning that appeared in no prior evaluation. One had resigned quietly, without explanation, 6 weeks after submitting an internal memo that, Patricia Howe noted, had never appeared in any hospital record she could locate, and one had been Rachel Morgan. Gerald Fitch's cross-examination of Patricia Howe lasted 11 minutes. I timed it. He began with his standard architecture, methodical, confidence-projecting, designed to introduce doubt. He challenged the affidavit's timing, suggested personal motivation, implied professional jealousy between departments. Patricia Howe answered every question in the same tone she had used with Diana Cole, measured, precise, completely unmoved. At minute 9, Fitch made his second mistake of the afternoon. He suggested that Dr. Howe's affidavit was the product of a broader institutional grievance, that she had, in his words, a history of conflict with hospital administration that colored her perception of Dr. Hale. Diana Cole objected. I sustained it. But the damage Fitch had done was not to Rachel Morgan's case. It was to his own. Because Patricia Howe looked at Gerald Fitch with the patience of someone who has spent 3 decades in rooms where precision is the difference between life and death, and she said quietly and without a trace of anger, Mr. Fitch, I have spent 28 years making sure that what I observe in an operating room is recorded accurately, because in my profession, the alternative is that someone dies and nobody knows why. I did not file that affidavit because of a grievance. I filed it because I watched a pattern repeat itself 4 times, and I decided that the 5th time, whatever form it took, would not happen in a room where I was silent. The courtroom did not react loudly. There was no audible gasp, no dramatic outburst from the gallery. There was something quieter and more powerful than that. There was recognition. I watched it move through the jury like a slow current, watched it reach each face and settle there, watched 3 of the 7 who had nodded during Fitch's opening statement look at each other, briefly, almost involuntarily, with the particular expression of people who have just understood something they cannot ununderstand. I looked at Dr. Marcus Hale. He was still composed. His posture had not changed. His hands were still folded on the table in front of him, but his attorney had stopped writing notes, and Dr. Hale had not looked up from the surface of that table for the past 6 minutes. In 30 years, I have learned that there is a specific kind of silence that intelligent people produce when they realize for the first time that they have lost. That was the silence I was watching. I called closing arguments for the following morning. I reminded both parties of the remaining procedural steps. I thanked the witnesses and dismissed the gallery, and then I went back to my chambers, Sat down in the chair I have occupied for 3 decades, and I did something I have not done in years. I sat quietly for a very long time, not because I did not know what justice required. I knew exactly what justice required. The law in this case was not ambiguous. The evidence was not ambiguous. The pattern was documented, corroborated, and devastating in its clarity. I sat quietly because of Thomas Ellery, because somewhere in this state, a 61-year-old retired science teacher was living with the consequences of 19 additional days in a hospital bed, consequences that would follow him in ways both measurable and immeasurable for the rest of his life. And he would never sit in this courtroom. He would never take that stand. His name had been spoken here today, and it had mattered, but he would never know exactly how much. And I thought about the 4 names. The 4 members of the surgical team who had done exactly what they were trained to do, who had seen something, said something, and paid for it. And I thought about how many others, in how many operating rooms across how many hospitals, were doing the math right now, calculating the cost of speaking, deciding whether the risk was worth it. The following morning, closing arguments lasted 2 hours. The jury deliberated for 3 hours and 40 minutes. They returned a unanimous verdict: wrongful termination. Proven. Damages awarded to Rachel Morgan in full, plus additional compensation for documented professional harm. The jury foreperson read the verdict in a steady voice, and I watched Rachel Morgan's hands, still folded on the table in front of her, pressed together slightly, as though she were holding something fragile and did not want to drop it. I sentenced my findings to the State Medical Board simultaneously. The board had already received Patricia Howe's affidavit. My documentation added to an investigation that had, I later learned, been building quietly for longer than anyone in that courtroom knew. Dr. Marcus Hale's medical license was suspended pending full review within 60 days of that verdict. His position at Hargrove Medical Center ended the same week. I did not feel satisfaction. I want to be precise about that. Justice rarely produces satisfaction, not the clean, cinematic kind that people imagine. What it produces, when it arrives correctly, is something quieter, something closer to relief. Before I closed this case in my personal record, I wrote 1 line in the margin of my notes. I do not do this often, but some cases earn it. I wrote, "She spoke when it would have been easier not to." That is not insubordination. That is the definition of integrity. If you take nothing else from this case, take that. The operating room does not belong to the most powerful person in it. It belongs to the patient on the table. And the moment we forget that, the moment we allow seniority or status or the calibrated contempt of exceptional men to silence the people trained to catch what we miss, we have stopped practicing medicine. We have started practicing ego. And ego, as Dr. Marcus Hale discovered on a Tuesday morning in late October, does not hold up well under oath.